Welcome to the month of December. We have very stimulating content lined up for you in the next 4 weeks. Head on to our Instagram handle and Facebook page to see the topics lined up for the month. Also, here on our YouTube channel, we have a new playlist on International Days. Check out that content. Leave your comments, engage with us, and let us know what content you would like to see as it relates to international law. For the fifth lecture in this lecture series, I will be sharing in a little more depth another source of international law mentioned in the very first video: Judicial Decisions and Teachings of the Most Highly Qualified Publicists. According to Article 38(1) of the Statute of the ICJ, Judicial Decisions and Teachings of the Most Highly Qualified Publicists of the various nations as subsidiary means for the determination of rules of law. This implies that judicial decisions and teachings of most highly qualified jurists are subsidiary sources of international law. If you like, you could say secondary or supplemental to other sources of international law that we already mentioned, which are the international conventions and international customs. So, what are referred to as judicial decisions and teachings of the most highly qualified publicists as it relates to it being a source of international law? To answer that question, we'll take a look at the Travaux Préparatoires, which is the preparatory document of the Statute of the ICJ. In that document, you will see that during the negotiation of the ICJ statute, Article 38, sub 1, sub c, which is the general principles of law recognized by civilized nations, which we discussed in our very last video, and Article 38, sub 1, sub d, which we're discussing in this video today, were suggested by negotiating parties to forestall the court from declaring cases non-liquid. So this concept we also discussed in our fourth video, so you can take a look at that. In this sense, you can see that Article 38 sub 1 sub c and Article 38 sub 1 sub d of the Statute of the ICJ are kind of gap fillers. So having said that, we'll begin to unpack in more detail what judicial decisions have been referred to as sources of international law and how the teachings of the most highly qualified publicists can be referred to as a source of international law. Now, for reference to judicial decisions. So the status of judicial decisions as a source of international law under Article 38 sub 1 sub d of the Statute of the ICJ carries a caveat. This source of law is qualified by Article 59 of the Statute of the ICJ. Article 59 holds that the decision of the court has no binding force except between the parties and in respect of that particular case. In essence, judicial decisions under international law are binding only on parties to a dispute before the court and only regarding the particular case in question. So as you would notice, the status of judicial decisions in international law as a source of international law is somewhat differentiated from the status of judicial decisions in many legal systems. This is because many municipal legal systems recognize the doctrine of stare decisis, and this is a legal obligation to follow an earlier decision with similar facts. Stare decisis is critically referred to as judge-made laws. But under international law, you will see that there is no obligation for international courts and tribunals to be bound by previous decisions made on cases with similar facts. One way to reason this through is that the doctrine of stare decisis is usually based on a structure that focuses on the hierarchy of courts. And this structure is absent in the international judicial system. So if you may say, it is more appropriate to consider that the ICJ regards its own judgment and those of the Permanent Court of International Justice as guidance in future cases. In other words, the ICJ follows its own authoritative findings of law in relation to the principle under consideration. So there is no obligation to decide a case based on an earlier decision. And to the question of teachings of the most highly qualified publicists. So there are very many important functions played by the most eminent writers who are frequently international law practitioners. These teachings, usually evinced in writing, take many forms, such as digests, articles, books, blogs, and so on. These teachings help to shape and put in order various strands that make international law. And so the teachings evinced in writing may be highly persuasive guides in framing the content of international law and have been referred to extensively by international courts and tribunals. For example, the Grand Chamber of the European Court of Human Rights referred extensively to writers to support its conclusion on jurisdiction in its 2001 decision in the case of Bankovic and Belgium. Suffice to note that Article 38 1D of the Statute of the ICJ has its potency as establishing law rather than creating law. What this means is that judicial decisions and teachings of the most highly qualified publicists tend to show in international law more what the law is than to set the law, that's to make the law. So referring to teachings of highly qualified publicists, the ninth edition of OPHIM's International Law sums it as, it is as evidence of the law and not as law-creating factor that the usefulness of the teachings of writers have been occasionally admitted in judicial pronouncements. So today, we have been able to look at the last source of law mentioned in Article 38, Sub 1 of the Statute of the ICJ. We have also been able to show from the Travel Preparatoire, which is the negotiating document of the statute of the ICJ, that this provision or this specific source of law was intended by the negotiating parties to be sort of a gap filler. And we have shown that this source of law is referred to as establishing law rather than creating law. So it has the function of showing us what the law is rather than making new laws. I want to say thank you so much for joining in. Remember to like, share, subscribe, and hit the notification button so that you're notified when there's a new video.